name is Victoria Bader, and I'm counsel for Appellant Mike Quan Hubbard. I would like to reserve 3 minutes for rebuttal. Today, this court must decide whether the newly enacted Violent Offender Registry violates the retroactivity clause of the Ohio Constitution. Prior to March 20th, 2019, an individual convicted of certain enumerated offenses was not subject to any form of registration duties. But after the enactment of that statute, any qualifying person who had not been sentenced or released from prison became subject to automatic offense-based registration duties. Because this registry is explicitly retroactive, this court only needs to answer one question. Do these new registry requirements constitute punishment? Mr. Hubbard asks this court to find that it does and hold that the new and additional burdens imposed by the Violent Offender Registry affect a substantial right in violation of the Ohio Retroactivity Clause. A statute is punitive and affects a substantial right when it imposes new or additional burdens, duties, obligations, or liabilities as to a past transaction. As this court has recognized, there is no absolute test or bright line rule to determine whether a statute is so punitive as to affect a substantial right. Instead, this court has looked at whether, as a matter of degree, the statute is so punitive that its retroactive application is unconstitutional. Here, there's no question that the Violent Offender Registry imposes significant new and additional burdens, duties, obligations, and liabilities that did not exist prior to the statute's effective date. This court has recognized that there are some factors that alone suggest a punitive statutory scheme. One of those is the fact that registry procedures and requirements are placed in the Ohio Criminal Code. And another is the fact that failure to comply with a registry requirement subjects an individual to additional criminal prosecution. Both of those factors are present in this case. This is a public, automatic, and offense-based registry, and it now requires individuals to register annually in person at the sheriff's office in their county of residence and provide a significant amount of information. That information includes their name, alias, date of birth, Social Security, driver's license, commercial driver's license, state ID number, home, work, and school address, the license plate and description of any vehicle that they're associated with, a photograph taken annually, and fingerprints and palm prints. Additionally, failure to comply or notify the sheriff of a change of address subjects the registrant to additional criminal prosecution, constitutes a violation of supervision, and may result in indefinite extension of those registration duties. The minimum period of registration is 10 years, but that can be extended for life. In fact, a court must indefinitely extend an individual's registration duties when the state files a motion and the court finds one of two things. Either the individual violated a term or condition of his sentence, or has committed a new offense of violence. And although the statute does allow a person to petition for removal from these indefinite registry requirements, any person whose registration extension was based on a new offense of violence is statutorily barred from removal and has to continue to register for life. This is the only registry that allows for increased registration duties after the registration duties were imposed. Additionally, every person is required to register unless before sentencing or release from prison, he files a motion to rebut the presumption, the court finds that he was not the principal offender, and the court determines that after considering several statutory factors, he should not be required to enroll. This rebuttable presumption is non-existent for principal offenders, and it is also nearly out of reach for currently incarcerated individuals who are without the means to file a motion to rebut the presumption prior to release. Further, this is a public registry. While the actual database maintained by VCI is not a public record, the statute explicitly allows for public access to nearly all of the information provided. The only information that is not subject to public inspection are the registrant's Social Security number, the driver's license number, the state ID number. All other information is subject to public inspection. And because there are no other limitations on access, all of this information may be subject to public dissemination. So there's no one single factor that makes this violent offender registry punitive. Instead,
Counsel, Counsel, how does the public access this record, these records?
So the public is able to go to any sheriff's office in the state of Ohio and request access to these. So it could be by traveling to the sheriff's office in person and requesting copies. It could be by calling or emailing the sheriff's office. Whatever their policy is for releasing these documents, there really is no limit other than the actual those three things that are precluded from public access. As I said,
Excuse me, does the Attorney General's office have a role? Does the Attorney General's office post this as well?
So the Attorney General's office is responsible for maintaining the database through BCI. And so it's similar to the sex offender database. I would imagine that it's used as an investigatory tool and maintained by the government. That database is not accessible online or by any other means to the public. However, nearly all of the information is a public record. So there's nothing that prevents any individuals, media, community members from going to a sheriff's office and requesting information either about a particular person or a large number of people, you know, for example, everybody in their county or everybody in a certain zip code asking for that information and then disseminating it publicly in the future.
So how does this differ from the arson registry?
So there are many similarities to the arson registry. This court has not considered the retroactive application of the arson registry. There are a handful of differences. First, the arson registry is actually explicitly non-public. So there is the arson registry is not available. It is solely an investigative tool. It is solely a resource for law enforcement officials and prosecutors, and it's not available to the public in any way. The other difference, obviously, the arson registry is a lifetime registry, and so that is the other major difference. But as far as the information that is required to be provided, it is substantially similar to the violent offender registry.
Thank you.
If there are no additional questions for me at this time, I'd ask this court to find that the new violent offender registry requirements are punitive, affect substantial rights, and that the retroactive application violates the retroactivity clause of the Ohio Constitution. And with that, I'll reserve the remainder of my time.
Thank you. Mr. Greer.
Chief Justice, Associate Justice, and Counsel, may it please the court. Sierra's law in this case is remedial, it's not substantive. And we know this because this court has given us a test to determine whether a statute violates the prohibition against retroactive laws. That test is set forth in Matz, set forth in Cook, Ferguson, and in 2012, it was set forth, reiterated in Watt. So the question is, first, did the General Assembly intend a statute to apply retroactively? In this case, it did. The state concedes that. The second question is, does the statute impair a vested right, affect an accrued substantive right, or place a new burden, obligation, liability on a past transaction? Now, this court has held repeatedly, starting in Matz, in Cook, Ferguson, and then reiterated in Watt, that the commission of a felony is not a past transaction that creates a reasonable expectation of finality. In the absence of that reasonable expectation of finality, when the appellant committed murder, since he had no reasonable expectation of finality, this statute would be remedial, not substantive. So we would ask this court to find that Sierra's law is remedial and does not violate the prohibition against retroactive laws set forth in Section 28, Article 2 of the Ohio Constitution. However, the analysis doesn't end there, because we have the Williams case, in which this court found that Adam Walsh violated the prohibition against retroactive laws. Now, in Williams, this court did not apply the framework and the test set forth in Matz, Cook, and Ferguson. So if you look at and compare Adam Walsh to Sierra's law, in the aggregate, you will see that Sierra's law is less onerous. Now, this court was mainly concerned with Adam Walsh with the frequency, duration, and scope of Adam Walsh as compared to Megan's Law. This court found that in comparison to Megan's Law, Adam Walsh was so punitive that it violated the prohibition against retroactivity.
Counsel, in what respect is this registry less onerous than the Adam Walsh Act?
Well, first of all, Adam Walsh is automatic. If you commit sexually oriented offenses, depending on which sexually oriented offense you commit, you're automatically classified either as tier 1, tier 2, or tier 3. There is no discretion with the trial court.
I'd like to focus on the burdens that it places on defendants subject to it. In what respect is it less onerous?
Well, the biggest burdens, as I see it, in comparison, Adam Walsh to Sierra's Law. In Adam Walsh, there is residential restrictions. No sex offender can live within 1,000 feet of a school, daycare center, or a child, or a preschool. Also, there's community notification. Adam Walsh requires the Attorney General's office to maintain a publicly accessible database regarding sex offenders. Not only that, sheriffs are required they have a mandatory public dissemination of information to certain members of the community, such as neighbors of a sex offender and certain like this, that doesn't exist with Sierra's Law. There is no community notification. The violent offender database there is no public access. The information that is stored in that database, for the vast majority of that information, is a matter of public record. So anyone could obtain this information prior to the effective date of Sierra's Law. So in that way, it is different and much less onerous. Sierra's Law is much less onerous than Adam Walsh. Not only that, with Adam Walsh, all sex offenders are required to register with the sheriffs of 3 different counties: the county they reside in, the county they work in, and the county they may go to school in. With Sierra's Law, a violent offender is only required to register in one county, the county in which they register, in which they reside. So,
Mr. Greer?
how you compare it, it is less onerous, substantially less onerous.
Mr. Greer?
Yes, ma'am.
I want to clarify, this applies to aggravated murder, voluntary manslaughter, kidnapping, and abduction. That's it, right?
Also attempted murder and only abduction as an F2. So it's a limited number of crimes. And I'm not sure if it applies to involuntary manslaughter. I'd have to look it up.
Oh, I think it's just voluntary. I misspoke. And then I think it involves with some complicity as well.
Yes.
Thank you.
Counselor, is it proper for us to apply to see whether this law violates the ex post facto laws of the United States Constitution?
No, Your Honor. No one has challenged this law under ex post facto. They've only challenged this law under Section 28, Article 2. Appellant also implies in his argument that there may be due process problems with the statute, but they don't argue due process. So the due process issue is not before this court.
If we found that the retroactive application affects a substantial right, can we still fine for the state?
Well, this court's test is that, and this court puts no qualifying language on whether it affects. It doesn't say, this court doesn't say whether it negatively affects a substantial right or positively affects a substantial right. It's whether it affects a substantial right. But in this case, appellant has not identified any substantive right that's been affected. So the question is, when he committed murder, the act of murder, did some substantive right accrue to him during the commission of that murder? No.
How about the right of fair notice? Of what sanctions you will be, can be imposed upon you if convicted of the crime?
This isn't a sanction, Your Honor.
I'm sorry, say that again?
Sierra's law is not a sanction. In fact, we are here today to decide whether it is a sanction.
Well, so how about sanctions or conditions? And clearly you'll say then the difference is conditions, what, have to be burdensome or have to be more than burdensome?
No, they have to be burdensome in the constitutional sense. The court has held in Matz, in Cook, in Ferguson, and in Watt that a burden has to be in the constitutional sense. And to be a burden in the constitutional sense, it has to affect that past transaction would have to, one, create a vested right, or that past transaction would have to have created a reasonable expectation of finality.
To a rule in your favor, do we have to overrule State v. Williams?
No. No, the best way to look at Williams, I think, is found in the Caldwell case from the First District, that Adam Walsh was so onerous that it simply couldn't withstand constitutional scrutiny under the Ohio Constitution, despite the fact that the commission of a felony does not create a reasonable expectation of finality. This court had the opportunity to address Williams again in Watt, and it didn't. So they exist in parallel. There is no need to overturn Williams if this court decides it was remedial.
Counsel, you didn't reserve time for Mr. Carney, but you've got 5 minutes left.
I'll reserve that for Mr. Carney.
All right.
Thank you.
Carney.
Thank you, Your Honor. Madam Chief Justice, it may please the court. The Attorney General echoes the state on the two key principles that show why Sierra's law can be applied validly to Hubbard here. First, the mild registration requirements here are closer to what the court already upheld in Cook and Ferguson and not like the ones that the court found to be a problem in Williams. And second, Williams did not overrule Ferguson's standard or judgment, but simply found that a different statute failed the test. It didn't move the line. It said a new law crossed the line. And that's why if this court were to side with Hubbard today, the court would not only strike down the violent offender database and the arson registry, but it would have to go back and strike down Megan's law under Ferguson and Cook as we've known it and been applying it to many offenders for over 20 years now. And the reason for that is twofold. First, if you look at the three statutes, what was okay in Ferguson, not okay in Williams, and look at this one, on every feature the court cited in Williams, we're on the good side. The court in paragraph 20 of Williams cited the frequency, scope, and duration, moving from annual registration for 10 or 20 years to every 90 days for life, moving to 3 counties, moving to 3 different sheriffs, all of those things. The feature cited by my friend on the other side, that it's in the criminal code or that it's a criminal violation if you fail to register, that's true of Cook. That's true of Ferguson. So if you say that's now a problem, you would have to throw out Ferguson. So they're asking you to go back and retroactively throw out Ferguson and Cook. And that's not just a matter of reasoning, that's a matter of outcome. We have a whole tier of offenders out there who every year are still registering under the Ferguson law because the court didn't let them move up to the upgraded Adam Walsh Act law. But if you went back and said that was a problem, then we couldn't have them register under Ferguson anymore. They'd have to go back to Megan's or the pre-Megan's 1968 law. Now, the only distinctions they could possibly offer would be as if they said, there's something different here. One, there's not, or two, if they said Williams did change Ferguson. We know Williams didn't change Ferguson for at least 3 reasons. Williams itself said so, White said so, and the outcome of how we've been living life this decade.
Counsel, let me ask you this. What about the inmates that this applies to, that your counsel on the other side said don't have the ability to rebut this classification and this registry's requirements?
Well, Your Honor, that's one of the many features of this that is identical to what the court said was okay in Cook and Ferguson. Some features, like how often you register, are less than what the court found acceptable in Ferguson. Other things, like that it's automatic for some crimes, although it's not fully, there is a rebuttable presumption that you can overcome in certain circumstances. But even if it were automatic across the board, that was the case for many offenders in Ferguson. And it was also the case that it was in the criminal code. But the question is there anything more onerous here? The only thing I could find was that now you have to identify tattoos or identifying scars or fingerprints. But those things, like identifying a tattoo, are public to the world. A lot of the things that counsel points to, like the basic fact of your conviction, are already public record regardless of a registry. You can go to the DRC offender site right now, look up Hubbard and see his date of birth and his crime. The other thing would be to say, oh, but is it a different type of crime? No, we don't say that there is no finality interest in the transaction of molesting a child, but there is a finality interest in being a murderer. Murderers don't have greater rights than sex offenders, Your Honor. And there is nothing they can point to that makes this statute more onerous than Ferguson. Chief Justice O'Connor's opinion of Ferguson remains good law, and we shouldn't throw it out. And again, White, which comes after all of these, cites Cook, cites Ferguson, even cites Matt. It never cites Williams. If you do a word search, you'll find Williams, but it's a different case. But more important, the outcome of Ferguson has continued to be the law. And I haven't heard counsel offer any distinction for how you could strike this law without rolling back Megan's itself, or at least the Megan's 2.0 that we've been applying for a decade under Ferguson.
But isn't that a problem if you're applying the law one way towards people who are lucky enough to have not been sentenced after the effective date of this law, and they're able to rebut the classification, but it all applies to a bunch of people who were never told about this when they were sentenced in prison, and they don't have the ability to do that. It applies significantly different requirements and the absence of requirements for large groups of people, doesn't it?
If I may briefly answer, I know I'm out of time. Your Honor, no, it doesn't. But if there were an equal protection problem, that would be a challenge brought by those folks under a different clause. That doesn't change the retroactivity, because the test is, do you have an expectation interest? And you don't have an expectation interest in committing a felony. And again, that's no different for murder than it is for sex offenses.
Thank you. Ms. Bader?
Thank you, Your Honor. So one of the things I wanted to highlight is there are 4 ways in which a statute can be substantive. If it impairs or takes away a vested right, if it affects an accrued substantive right, if it imposes new or additional burdens, duties, obligations, or liabilities as to a past transaction, or if it creates a new right. The state has focused heavily on whether or not individuals have a vested right to not be on a registry. However, this is about the 3rd prong of that four ways that I mentioned, the new additional burdens, duties, obligations, or liabilities. And that's exactly the same thing that was considered in Williams. So the reason that vested right language didn't appear in Williams is because that wasn't the pertinent part of that rule. Instead, the court was looking at new and additional burdens, and that's exactly what we have here. The state wants this court to apply a test that they believe was laid out in Mass and reiterated in Cook, but the test that this court set forth in Williams is that it is a matter of degree whether a statute is so punitive. Like as I said, there is no bright line test or rule here. It is as looking at the matter as a whole, at the statutes as a whole, figuring out whether those requirements are so punitive that they rise to the level of affecting a substantial right. And Williams and the Adam Walsh Act is not a floor for what is punitive. This is an individualized determination, and this court has to look at all of the factors of this specific registry and this specific statute to determine whether these new burdens and duties that did not exist before March 20th of 2019 are so punitive as to affect the substantial rights. This does go back to the basic principles of the retroactivity clause, that statutes can't reach back and create additional burdens that didn't exist prior to the time of its effective date. Additionally, I wanted to highlight Justice Donnelly's point that there are individuals that we know are unable to rebut the presumption, even if they were not the principal offender, because they are incarcerated. Individuals who are incarcerated for 10, 15, 20, 30 years are given notice within a reasonable time of their release. And that duty is put on the Ohio Department of Rehabilitation and Correction to determine what a reasonable time is. My hope is that those individuals would get sufficient time to file a motion on their own in the court. But what we know from amicus counsel in their brief is that there are individuals who have been given 2 days notice. And that is certainly not enough time to file a motion, get it in the mail through the DRC mail system, and get it to a court in a timely fashion. And if that motion is not received prior to the time of release, that person has no ability to rebut the presumption at all.
Counsel, would you address the third prong that was mentioned by the state's counsel, finality, expectation of finality upon the creation, the conviction and sentencing for felony, in this case, the cluster of felonies that it addresses?
Yes, Your Honor. And so that language comes from Matz historically and has been cited by this court numerous times. In State v. Matz, that case actually involved whether an individual with a felony conviction would be able to receive victims of crime funds. And in that case, this court found that an individual does not have an expectation of finality, that no future legislation will hinder them or create a disability based solely on the fact that they have a felony conviction. And what Williams showed us is that is part of this court's prior jurisprudence, but this is a substantially different circumstance. And as Williams showed us, there is a line, there is a certain point at which this court has found that things become so punitive as individuals do have an expectation in finality and in their constitutional right to not have retroactive laws enacted that affect them and create new and additional burdens.
If we were to accept your argument, wouldn't we have to overrule both Cook and Ferguson?
No, Your Honor, I don't think that's the case.
It's hard to say that this system is more punitive than those systems, right?
No, Your Honor, there are portions of this new registry that are more similar to the Adam Walsh Act, and there are portions of this registry that are similar to Megan's Law. This is its own registry. It has very different requirements, but some of them are the same as both. One of the things I'd like to note is that the sex offender registry statutes, the sex offender laws have been considered by this court over the course of decades. And every time there has been a consideration, has been due to amendments. And so this court has been kind of viewing a subset of amendments at various times. But what we have here is we have a significant number of new and additional burdens that did not exist. So this isn't looking at, from Cook to Ferguson or Ferguson to Williams, where there are a small number of changes when this court has already considered something to be remedial. And as this court noted in Williams, there can be some remedial aspects of a registry, but other elements, or looking at it as a whole, can make the statute no longer remedial.
Ms.
So
Bader,
can this statute be, severed? Certain portions, certain requirements severed by the court?
This court could choose to sever certain portions of the statute, but our position is as a whole, the entirety of the statute, looking at it as a whole, is unconstitutionally retroactive, and individuals who committed their offenses before the effective date should not be required to register moving forward in any capacity under this new registry scheme.
If it's found to be punitive, but if it's remedial, that's not the matter, or that's not the case, correct?
Correct, Your Honor.
All right.
Ms. Bader,
Yes.
The information that would be available to the public through the sheriff's offices sounds like there's a lot of duplication on what's in a pre-sentence investigation. I mean, if I heard right, even tattoos of the person would be subject to disclosure, which you can find those in the PSI. And I disagree with counsel that we can readily see those because a lot of times that's not the case. Compare the information that's available on the registry with what's in a pre-sentence investigation, which we don't disclose to the public.
Yes, Your Honor. So, well, I think it's also important to look at what's on the docket. There are certain aspects of this that are available on the public docket, as the state noted: name, date of birth, then current address. Those sorts of things would be available. And then, in regard to your question about PSIs, those aren't typically public information or readily accessible by the public, but those would contain details about then current tattoos, marks, distinguishing features, family information, maybe additional addresses and those things. But the important thing about this registry is this is a real-time registry that lasts for 5 years, or in some in cases for life. And so if anybody obtains new tattoos, new distinguishing features, new cars, new vehicles that they're associated with, new work, school, home, addresses, all of those things need to be updated. Change of address needs to be updated within 3 days of a change, or the other information is updated annually. So when an individual commits an offense, there is a limited amount of information that is publicly available on the docket or in a pre-sentence investigation report. However, moving forward, this person has to update that information regularly. And so all of that information is current and accessible to the public.
Thank you.
If there are no further questions, I ask this court to find that this statute affects a substantive right in violation of the retroactivity clause of the Ohio Constitution.
Thank you. Thank you very much, counsel. We will take the matter under advisement and you'll be notified of our decision. Okay. Our next case is 2020-549, the state of Ohio versus Albert Jarvis. For the appellant, Ms. Bennington.
Chief Justice O'Connor, fellow justices, may it please the court. My name is Taylor Bennington. I'm with the Muskegon County Prosecutor's Office on behalf of appellant state of Ohio. I'd like to reserve 5 minutes for amicus and then reserve 2 minutes for rebuttal. Today, we're asking this court to resolve a conflict that exists among the appellate districts on whether Ohio's Senate Bill 231, which established a violent offender database, violates Section 28, Article 2 of the Ohio Constitution. Your Honors, I would reaffirm what my colleague from Butler County has said this morning, and given the fact that the issues are identical, I'm not going to repeat the argument made by him, but I would like to highlight the key holdings I believe are dispositive of the issue today. The standard for determining whether a statute's retroactive application violates the retroactivity clause has already been established by this court. We're not asking this court to create a new standard. We're simply asking that the standard be applied to Sierra's law. And the question is whether Sierra's law is substantive or remedial in nature. According to this court, a substantive statute, for our purposes, is one that imposes new or additional burdens, duties, obligations, or liabilities as to a past transaction. And we don't have that here because the commission of a felony is not the type of transaction that creates a reasonable expectation of finality. This court has consistently held that felons have no reasonable right to expect that their conduct will never thereafter be made the subject of legislation. So at the time Mr. Jarvis committed the offense of kidnapping, he had no reasonable expectation of finality with respect to the absence of any post-conviction regulation. And as such, retroactive application of the violent offender enrollment statute does not create a new burden in the constitutional sense. I would further like to note and remind the court the details of how in every measure, whether it's duration, frequency, or scope, Sierra's law is less onerous than even Megan's law, which this court found to be remedial and upheld in Ferguson. And so, Your Honors, in applying the tests that this court has set forth and repeatedly used in Matz, Cook, Ferguson, and White, Sierra's law is remedial and does not violate the Ohio Constitution when retroactively applied. Unless there are any new questions, I would defer to Mr. Kearney at this point.
Mr. Kearney.
Thank you, Your Honor. Again, we'll repeat everything we said in the first case, but to continue that conversation, I haven't really heard anything concrete that rebuts the notion that their entire view depends on trying to substitute the Ferguson dissent for the Ferguson majority. And again, that's not consistent with not only what Williams said, where Williams said, look, this statute crosses the line, we're not moving the line, but also the particular things they pointed to are primarily things that were features already in Megan's and Cook. One of the things, and I apologize for blurring cases, but since it's all the public defender on the other side, I hope it's okay. But one of the things counsel said was that, well, in the Megan's Law cases, there was always an incremental move from Cook to Ferguson or Ferguson to Williams. Well, that's not true. When Cook came online, what had been the law in 1968 was very minimal. Virtually everything in Cook was brand new duties to come in and register. And this court said that was okay. And so to say that's not okay anymore would call Cook and Ferguson into question. There's no way to rule for them without overruling Cook and Ferguson. And in particular, I know in both briefs in Jarvis and Hubbard, they repeatedly cite the Ferguson dissent. And the Williams court did not substitute the dissent for the majority. It reaffirmed the majority. And the things that it said crossed the line were things like the duration, frequency, and scope. At most, the one or two things like tattoos and scars are a little different now and admittedly are closer to Adam Walsh, but that doesn't mean we're going into an entire pre-sentencing report. It just means you show us what identifying characteristics you have, like in a photo. And again, a photo is already on the DRC website. There's nothing new about that. But if for some reason a particular offender does think that that is going to harm him, there is a provision in this, and I want to stress this is distinct from the rebuttable presumption on the front end, where you can get out of the statute entirely if you're not the principal offender. But separately, you can go to a court at any time during your 10-year period, and if you meet the requisite showing, have that information in the sheriff's office be declared no longer public, even the stuff that is public now. So there is already a remedy built in for that. But overall, the bright line rule has always been this idea that the expectation of finality that we apply for civil things in retroactivity doesn't apply to felonies. To the extent that there's some tension in Williams about matter of degree versus the bright line approach, there are a couple of answers to that. The most important is that you don't have to work out whatever analytical glitches there are in Williams. You don't have to change today because we know the outcome of the statute upheld in Ferguson was more burdensome than here. And as long as the outcome here is an easier case, you don't have to smooth that out. But if you do want to smooth that out, the answer is that Williams imported some notions from the ex post facto clause. The court openly cited the Kennedy federal case, Kennedy versus Mendoza Martinez, which has a matter of degree 7-factor test. Well, first, White already got that back on track by not citing Williams and by citing Ferguson. Second, if somebody has a matter of degree case they want to bring, they can just bring an ex post facto challenge, just like they can bring an equal protection or a due process challenge. I do want to note, as far as those long-term confined, that's not this case. Jarvis or Hubbard are not in that category. They're not bringing that challenge. The court shouldn't reach out to challenges not brought. But ex post facto should stay in its own box. Someone can always bring an ex post facto challenge. But at best, if you need to harmonize them, I believe the way Justice DeWine's opinion on the first district and Caldwell did it was just right. And it said, perhaps there is at the outer limit some idea where something is so punitive that it does trigger your expectation interest because you expect to face perhaps registration duties, but you don't expect to be punished. So if you're punished, that exceeds expectation. But again, nothing about these registration duties, annual for 10 years, is easily softer than what's upheld in Ferguson. So I don't see how you can say this is more onerous unless you say, well, it's not onerous to do it to a child molester, but it is onerous to do it to a murderer or kidnapper. I don't see what the basis for that is. This court has never said that the crime that was the basis changes the analysis. The court only looked at the duration, frequency, scope, residency, the push notifications, all of those factors, which again are either lesser or at most the same, other than the tattoos. If the court finds a reason to sever that, fine. We don't think there's any reason to. We don't think you have a finality interest in the tattoos you had of the day of your murder versus new tattoos you've gotten today. That's basic identification. And again, that's only kept with the sheriff, and you can petition to have that removed from the public domain. I see there's still a lot of time left, so I'll save for a longer rebuttal for Ms. Bennington and not use up my time as usual, unless there are further questions. But again, we ask the court to uphold this law because there is no way to strike it down without taking out the Megan's regime for decades and decades. And this court did not do that in Williams, and it certainly should not do that today.
Thank you. Thank you, Mr. Kearney. Mr. Hardwick.
Thank you, Chief Justice O'Connor. May it please the court. I'm going to start briefly on the procedural issue unique to this case. And I understand why this court would want to give the state the opportunity to brief the issue, but there is no certified conflict exception to the forfeiture doctrine. In the one-page argument that the state filed in the Court of Appeals, they argued one thing, and that's that the statute wasn't retroactive because it applied to convictions that occurred after the effective date of the statute. That's it. In this case, they are arguing now that yes, it is. They are conceding yes, it is retroactive, but it's constitutionally retroactive. And I ask this court to do one of two things: either dismiss this case as improvidently allowed and resolve the conflict in my colleague's case, the Hubbard case, or if this court decides it needs to resolve the conflict, then it needs to take the next step and say, how does that legal question apply to this case? And even if this court resolves the conflict in favor of the state, this court should nevertheless affirm, because again, the state's one-page argument on making a completely different argument in the Court of Appeals did not preserve the argument they are making in this court. But as to the merits, I want to go briefly. The one thing that's different about the Cook, Ferguson, and Williams trilogy that is different from the other cases is that they're the only cases that apply the retroactivity doctrine to the question to the remedial substantive doctrine, to when does something become punishment enough that it passes from remedial to be punishment. And well, cases like Matz did not address substance, that didn't address whether a person had a entitlement to recover funds from someone who's done them criminal wrong. It only addressed the means to recovery. And White, again, didn't create a new right, or didn't take away a right, a substantive right, to just say, well, how do we address your right to a appropriate voir dire, to a lawful voir dire, and talk about the procedure for reaching that. I also disagree strongly with my friend on the other side. We don't ask this court to overrule Cook or Ferguson. And my colleague talked about how Adam Walshak wasn't the ceiling. Excuse me. Make sure I get this. Wasn't the ceiling for substantive law, but Ferguson, wasn't the floor. Ferguson was the ceiling for what is remedial. This court, when it issued Williams, said, look, Ferguson was a close call, but now you've made things even worse, and put all doubt, and this court said that all doubt has now been removed. The doubt has been removed. That's because Ferguson was the ceiling for what the state can get away with and still call it remedial. And it is a lot. It is work.
Even if that's true, I mean, is this scheme really more onerous than the one in Ferguson? I mean, when I look at it, it seems to me that if I had to comply with one or the other, I would rather comply with the one here than the one in Ferguson.
Well, it works in a number of ways. First of all, unlike Ferguson, this is solely offense-based. The system under Megan's law was, unless there was a finding that you were dangerous, your registration ended after 10 years, full stop. Nothing happened after. You were done after 10 years. And the only way you went above 10 years was a finding of dangerousness. That doesn't happen here. You have to provide additional information to the state that you did not have to provide before. This is extendable for life. Extendable for life.
There's no other community notification things and there's other things, right? Though. I mean,
there's no mandatory community notification, but I know from other cases I've dealt with, sheriffs don't know. Sheriffs, at least with sex offender laws, have sometimes gratuitously issued community notification just because they want to. There's nothing in the statute that stops a sheriff from doing community notification if they want to. And that does happen in some sex offender registration cases as well. And that when the state wrote in the brief that this, and my friend and I wrote in the brief that this isn't a public record, it is expressly a public record, unlike the arson case, which says this is not a public record. This is a public record. And I can't imagine any other situation where you just say just because something isn't affirmatively required to be on the internet, it's not public. That's just not the way public records work. Even small things like my friend on the other side said, well, the photograph isn't anything new because that's on DRC's website. Well, that's not true after post-release. After your supervision is done, DRC takes your photos down. DRC takes all your information off of their website once you get off supervision. And they do that very intentionally because they want you to have a chance to reintegrate into society. They found that people were using that database to not give people apartments, to not give people jobs. So Department of Rehabilitation Corrections very admirably now takes down that information. You cannot find someone's picture on DRC's website if their time has, if they are no longer under supervision. And I do think it's important to note how this is extendable. This is extendable upon any violation of post-release control, any violation, and it's mandatory on motion of the prosecutor. If you are 1 minute late on your curfew one day, the prosecutor can get you extended indefinitely. And then, yes, you can ask after 5 years, you can ask to be taken off, but there is nothing that requires the judge to ever take you off. There is no requirement. A judge can, at his or her own whim, deny a motion without explanation. And as long as they don't express, and the only way that you may be able to challenge a judge's decision to deny that motion is if the judge expressly gave some improper reason, like I'm denying your motion because of your race or something along that way. As long as the judge doesn't say that, the judge.
Counsel, is there a hearing required when the prosecutor motions to extend?
Yes.
Okay.
Yes, you do get a hearing. The problem is on our side, it's utterly standardless. There are some things that prevent the judge from taking you off the list, but there is under no circumstances is the judge required to take you off the list. None.
No, I'm talking about the hearing when the prosecutor moves for a minor violation of probation to extend the registration requirements.
Yes, you do get a hearing, but by statute, the statute states that if the judge finds a violation, the judge must extend the time. The judge has no discretion not to. There's no, I know this court in other cases has dealt with issues, what's a technical violation, what's not. There is no technical violation exception to this. It's any violation of your community control, your post-release control. And again, 1 minute, one day late on your, when you've been under post-release control for 4 years and 364 days, and you have it extended indefinitely to life at the judge's whim.
Excuse me, Mr. Hardwick, I think I saw something in the statute that there can only be 2 requests made in a 5-year period.
Yes, for some reason I thought it was only 1 every 5 years. My recollection is 1 every 5 years. You have to wait 5 years if you have it denied. You have to wait 5 years.
And that's to what does that apply to?
That applies if you have been if you've committed that your one post-release control violation, has the judge extended indefinitely, you can come back every 5 years and ask the judge, okay, let me off now. And the other thing about that is you have to be able to show that you've been able to pay off all your restitution, so that if you can't, in your fines, so if you can't afford to pay off your fines, you're on it for life. You're mandatory. The judge has no discretion. If you can't afford to pay off your fines, you are on this list for life. And I don't understand how, my friends on the other side have never shown how there's a public safety interest in keeping someone on the list just because they can't afford to pay off their fines. But that's what this does. That's also part of why this is punishment. I also want to just one of the factors that this court, that I know the first district addressed in Caldwell, where it talked about how, well, this is only a quote short prison term because it's a year, it's an F5. Just a year in prison is a life-changing event. It can be life-destroying. People lose custody of their children, they lose their jobs, they lose their homes, they can lose, and if it was the last year, depending on the prison they go into, they could have probably more than a 75% chance of getting COVID. A year in prison is not a short time. It is a long time. Yes, it's not as long as people get for other offenses, but it is still a very long time to have your rights taken away. I also want to, like, friend of the side talked about this, chance to rebut, for someone in prison, the chance to rebut the presumption of that they were the principal offender is the same as what happened in Cook. Well, that's wrong, because in Cook, you are a sexually oriented offender unless before you left prison, the state took an affirmative step to ask for a hearing to make you a sexual predator, to have a judge designate you as a sexual predator. Nothing additional happened. You didn't lose any rights by not filing anything before you left. But here, DRC, and as Amika says, sometimes it's 2 days before they leave. You get notified. You have zero chance to ask to be left off this, to taken off this registry. Zero chance to ask that you're not a principal offender, because all the statute says is a reasonable time, and there's also going to be times when I've had clients who get out, who find out the morning of that they're leaving prison. They didn't know the day before. They win something on appeal. Their sentence gets shorter. Well, then they get no notice at all, and they have no chance to take themselves.
Well, counsel,
off.
if they won something on appeal, chances are this isn't going to apply to them.
Well, it depends. In a sense, if they're short, I've had their prison term get shortened, where they say maybe a gun spec gets thrown out, and now they've already served their time of their underlying offense. So the wins on appeals tend to be more. We rarely get someone's conviction completely vacated. It's more frequent that they have part of their sentence vacated and they get sent out.
So, counsel, are you saying if they have a very short window of time once they are released from prison, and they don't have adequate time then, for example, the public defender or even private counsel to address this with the court, they automatically are required to register?
Correct. Actually, they have zero time after release. Once they are released, it's too late.
Okay.
Once they walk out of prison day, it's too late.
All right. It's too late to petition the court for a hearing?
Yes, to ask for a hearing on whether they were not a sexual, on whether they were not the principal offender. If you were
the court does not have any discretion to hold a hearing and make a determination?
I see none in the statute. My friend on the other side will make that concession. My guess is if they didn't make that concession here and I tried to argue, they'd argue it was jurisdictional. Because I see nothing, the statute says the motion has to be made before they leave prison. And I don't see any exception to that in the statute. And again, this is a punitive statute. Okay. Looking through. Unless there are any other questions, I just want to finish with saying that Williams, make sure I get my floor and my ceiling analogy right. Williams is not the floor for what is punitive. Ferguson is the ceiling for what is remedial. Williams did leave Ferguson in place, but Williams made it clear that Ferguson was right on the cusp. And you can look at it from a lawyer's practical point of view, you can look at it and say that, okay, now Ferguson was 4-3, and it said that this is barely constitutional. They pushed it further, but we can go more than just the lawyers looking at it and counting votes and saying, no, the majority in Williams said that Ferguson was a close call. And just as the General Assembly went farther when they dealt with, when they created Adam Walshek, they stepped beyond Ferguson when they created the Violent Offender Registry. This is now punitive, and when something is punitive, it is substantive, and it can't be imposed retroactively. And I ask this court to either dismiss the certified conflict as improvidently allowed, or to affirm the decision of the 5th District, either because we win on the merits, or because even if this court rules on the merits for the state forfeited the issue and therefore is not entitled to relief in this court. This court should not permit the state to use briefing in this court as a substitute to filing a proper brief and argument in the Court of Appeals. Thank you.
Thank you. Right, there's 6 minutes and 42 seconds. Who will do the rebuttal? Looks like Ms. Bennington.
I believe Ms. Bennington is rebutting, but she does seem to be frozen.
Why don't you take a stab at it, Mr. Curry?
So
Okay.
if you want, and if she pops back up, I will gladly yield the floor right back to her. But she does seem frozen. First, as to the forfeiture issue, that obviously is best answered by the prosecutor. But I will say this, that the idea that something is simply not retroactive versus saying, oh, it is retroactive, but it's the permissible kind of retroactivity, is something this court in Doe v. Ronan has equated before. And it's basically two ways of saying the same thing, that if in Doe, the court looked at a case where the new obligation was for someone to lose their teaching job based on a decades-old marijuana possession conviction. And this court said, because it's a future loss of something based on a past thing, that doesn't mean it's actually imposing a past duty. It's simply a future consequence. In that case, they called it not retroactive at all. The difference between calling something not retroactive or calling something permissibly retroactive is merely a semantic difference. So whether it's 1 pages or 20 pages, the brief covered the same concept. I see Ms. Bennington is back, so I'm happy to hand it to her back or say something quickly as Ms. Bennington.
Well, before you relinquish, Mr. Kearney, what do you say to the one of the last points that Mr. Hardwick made, which is, I guess, indicia of punitive nature, is the preclusion that an inmate cannot challenge once released from the institution, that challenge has to be made before leaving the institution. And oftentimes there's a very short window, small window, and an impossibility. So first of all, is that accurate? And if so, how would you view that?
Okay, 2 things. First, I apologize. I am at the disadvantage because that's never been briefed. That is not Mr. Jarvis or Mr. Hubbard's situation here today, because they are not long-term serving prisoners. They were newly convicted. They were right on the cusp. They counted as confined because they were being jailed and held for sentencing. If someone has a problem that's procedural, that's a due process violation of I didn't get adequate notice and hearing. Someone who actually is in that situation needs to bring a due process challenge, because if we're making a mistake in giving 2 days versus a week versus 2, and if we need to fix something, I will look into that as soon as we get out of this argument. But that is something that someone needs to bring. That doesn't make something retroactive or not. Something is retroactive based on the duties.
But counsel, it would, I guess, add to the punitive analysis, the lack of opportunity to challenge. But I understand your response. You'll yield to Ms. Bennington now. Is that my understanding?
Sure. I only plan to do 5, and I know I usually go over. So Ms. Bennington just froze up, so I'll hand it back to her. And we, of course, ask that you uphold this law because it is milder than what was in effect in Ferguson.
Ms. Bennington?
I would like to quickly address what my friend from the other side said regarding the forfeiture issue. In the lower court, the issue of whether Sierra's law violates Ohio's ban on retroactive law was raised by Mr. Jarvis. So the issue was properly brought before the 5th District. I know Appellee cites the State v. Gwynn and State v. Quarterman in support of his argument. However, both of those cases are distinguishable because in Gwynn, neither the state nor the defendant raised the issue in the lower court. The appellate court raised it sua sponte. It was later found to be forfeited. And then in Quarterman, the defendant failed to raise the challenge in the trial court, therefore forfeiting the issue. So those cases are distinguishable. That's not what happened here. The issue was properly presented and addressed by the parties before the 5th District. So the certified issue was not forfeited in this matter. Now regarding I'd like to correct the claim that Sierra's law is more onerous for several reasons. First, on the features of this.
Well, it looks like we're back in the land of frozen. Mr. Carney, do you want to pick up the mantle here?
Sure. This is a more interesting ball passing back and forth than usual. I'm not sure exactly where Ms. Bennington was going on the particulars of Quarterman, and so I will note that as to forfeiture, it's rather ironic that my friend on the other side is complaining about the degree of preservation by the state on the semantic difference between retroactive or impermissibly retroactive, but then brings a whole new, never before briefed, not raised by Mr. Jarvis's facts, claims about people getting out of prison and the due process they're given. So if we're going to hold to what was brought or not brought, or what's raised by these, I would think a goose gander rule should come into effect there to say, well, wait a minute, we can't quite do that. But as to the particular distinctions or comparisons drawn to Adam Walsh, again, the ones, if you really look at Williams, what the court called out is saying, whether you call it on the cusp, over the line, oh, only 4 votes versus 5 or 6 in Ferguson. I've never known this court to say a precedent has less weight because it had only 4 votes instead of 6 or 7. But the bottom line is that the things the court pointed to as the distinctions jumping from Ferguson to Williams were frequency, scope, and duration of registering every 90 days for life versus only for 10 or 20 years. Here it's every year for 10 years. So by that measure, this is so far less than Ferguson that I really don't see a way to say this is worse than Ferguson, other than a number of features that, again, were already in the Ferguson law. I understand they don't want to take on Ferguson in the decades of Megan's law, because the outcome of that would be devastating throughout our offender system, but there's no logical way to distinguish those. But also the idea that White, this court already in White, re-upped and cited Ferguson, but did not cite Williams. So if Williams did sub silentio move the ball, White has already moved it right back, but they're asking you to move it into a place this court has never been and relieve the registration duties of not only all the murderers. Final thing, since I do see we're out of time now, is he mentioned, well, this has the punitive effect of if you don't comply, you could get convicted of a crime and serve an extra year, and that'll hurt custody or job seeking. I humbly suggest that someone who's done 20 years for murder, having 1 more year on their record for failure to comply is not really going to change that. And also that feature was in effect and was even a higher felony in Ferguson than it is here, where it's F5 versus F3 there. So there's no way, again, that could be the distinction. So you need to uphold this law as well as what you've already upheld before. Thank you.
Thank you, Mr. Kearney. Ms. Bennington, you're out of time, so I'm going to tell you all, we'll take the matter under advisement and you'll be notified of our decision. Thank you. Marshall, will you call a recess?
The court will now adjourn for a brief recess.
Our third case this morning is 2020-599, the State of Ohio versus Manson M. Bryant. For Mr. Bryant is Mr. Hirsch.
Chief Justice O'Connor, and may it please the court. My name is Max Hirsch on behalf of Manson Bryant. I'd like to reserve 3 minutes for rebuttal. Mr. Bryant's outburst only revealed shock and anger over his sentence. His comments were directed at the trial court alone, and they did not contradict his previous statements of remorse. Therefore, the trial court lacked a lawful basis for increasing Mr. Bryant's sentence by 6 years. This court should reverse. The broad language of Revised Code, Section 295308, permits courts of appeals to review findings made by a trial court, even if sentences as a whole are no longer reviewable. Thus, the question here is whether the record contains clear and convincing evidence that the trial court's findings surrounding Mr. Bryant's outburst were contrary to law. Considering the meaning of remorse, Mr. Bryant's statements, and all the surrounding circumstances, the trial court's modification here was unlawful. According to Black's Law Dictionary, remorse means a strong feeling of sincere regret and sadness over one's having behaved badly or done harm. And to look at Mr. Bryant's statements that he made in his pre-sentencing allocution, which did reflect remorse that the trial court did consider. Mr. Bryant acknowledged that he's made a lifetime of bad decisions, and he regretted the harm that he caused to his family. He also said despite his addiction, he acknowledged that any change in the future would have to come from him. After the sentence was announced, Mr. Bryant reacted, and he used profanity, but nothing he said contradicted those previous statements. Instead, what the record shows is that he was reacting to the court's sentence. One of the first things he says was to bring up that this was 22 years. He accused the court of being racist, and he accused the court of never giving him a chance.
Counselor, can a court really determine whether someone is remorseful? I mean, how do you know, is there some mechanism a court can determine remorsefulness from good acting to lawyers saying if you say these things, it will get you less time? Or, I mean, how do we really know? Or how does a court really, trial court know?
To be sure, it's going to depend on the facts of the case. It's going to be a subjective judgment in many instances. And the trial court here did make an express finding that Mr. Bryant expressed some remorse in deciding that a 22-year sentence was appropriate. And we're not asking this court to reweigh that degree of remorsefulness. The question is, after the trial court made that finding, whether it could then revoke that finding based on Mr. Bryant's behavior. It was, in that sense, a legal error for the trial court to find that Mr. Bryant's outburst had some bearing on remorsefulness. Where Mr. Bryant was...
Counsel, let's place the outburst in context. The allocution in which he expressed remorse for his past actions took place before the sentence was imposed. Is that correct?
Correct.
Okay. And so as he awaited his sentence, he was aware that the co-defendant in this case, who arguably is more culpable of the more heinous aspects of the crime that was committed, he pled and he received a 12-year sentence. Is that correct?
Correct.
And so the trial court was asking for something because it was arguably the facts, it was less culpable, Mr. Bryant. They were advocating for a sentence more proportional, somewhat less severe than a co-defendant received. Is that correct?
That's correct.
Okay, so, and I reviewed the sentencing memorandum from the state. They were not advocating for a certain number in the written sentencing memorandum. They just asked for consecutive sentences. Is that correct?
To be honest, I haven't looked at the memorandum. I think during the sentencing, the state asked for maybe something closer to 20 years, but I don't believe they asked for an exact number.
So, given the outburst, isn't it more probable that it had more to do with the reaction to the severity of the sentence than a betrayal of remorse?
Absolutely, and it's not just the and I just referenced the word. Absolutely, and I just referenced the words Mr. Bryant used in response, but Your Honor points to the timing as well. The Mr. Bryant's counsel of the state, they all made their statements with respect to sentencing during the hearing, and the trial court began explaining its reasoning for the sentence, weighing all the factors and so on.
Counsel, let me interrupt you there, because I mean, I think that those things, at least seem to be clear from a legal standpoint, based on the law. How can this court change the trial court's imposition of additional 6 years when, and if you concede this, a trial court can change a sentence anytime before journalizing it, or making it final, I should say? How do we reconcile the law that gives the trial court the ability to do that?
The trial courts are required to consider the sentencing factors in crafting the sentence. And what happened here is pretty unique in that the trial court announced a 22-year sentence, which is not in dispute here, and then made a discrete, specific finding that impacted the sentence in a specific way. We know that it was changed by 6 years based on a specific finding made by the trial court. And that finding should be subject to review here on appeal.
Mr. Hirsch?
It is being reviewed, but again, how do we reconcile what it is that you ask us to do, at least under what umbrella of law, when the law is clear that before the judge made the sentence final, it could change the sentence?
The trial court made a finding that Mr. Bryant's outburst was related to remorse. So this court can review that as a legal matter, whether Mr. Bryant's behavior actually showed that based on the record before it. And as Justice Donnelly pointed to, all the words and all the surrounding circumstances showed that Mr. Bryant was having a heat of the moment reaction to learning that he was going to spend the next 22 years of his life in prison.
So you concede, although the trial court can change the sentence before it makes it final, you're arguing here that the reasons for the change here are illegal and should therefore be reversed.
Exactly, and a trial court can certainly consider new information or can consider a defendant's behavior in certain circumstances. Imagine a defendant who directly threatens the judge, or who makes a comment about the victim, or
well, how can a threat? What would a threat to the judge? How would that make that any more or less likely that he's remorseful?
Well, that would maybe not directly on remorse, but that would certainly relate to recidivism. That someone making a criminal threat in response to committing a separate crime in response to a sentencing announcement, that would at least be reasonably related to it. Here, Mr. Bryant, again, as the 11th District pointed out, a person can be sincerely remorseful yet still have a negative reaction to the sentence that was imposed. Mr. Bynes, who was more involved in this crime, who also broke into the trailer, additionally committed an assault and seemed to take the lead on scoping it out and so on, got a 12-year sentence. And in light of that, counsel for Mr. Bryant requested 10 years.
One more question, anything else, and then I'll be quiet when you finish. Some of Mr. Bryant's insults and profanity-laced tirade to the trial court dealt with issues of race. Is there anything in the record that indicates the race of Mr. Bryant's co-defendants?
No, not on the record.
Okay, thank you.
Mr. Hirsch, I'm looking at what was in the transcript, and your client, the judge said literally he's been to prison 3 times on 4 cases. He's got 9 prior crimes of violence before this case. He's got 11 instances of probation violations, resisting arrest, obstructing justice, in contempt of court, and numerous convictions, as well as a history of juvenile delinquency. So I guess I'm having difficulty understanding how it even really matters whether what the judge did in terms of her sentencing, whether it was the initial sentence or before she was done with the whole sentencing on the record, added more time to it because she essentially changed her mind on the record. I guess my concern is really more, was the judge able to do what she did, and not so much whether we judge substantively the content of what she had to say, because she put the reasons on the record relating to the factors. So whether it's remorse or anything, I mean, why does that matter? What the judge said about, I guess he's not remorseful, as I thought.
Well, I have 2 points in response to that. The first being that Mr. Bryant's criminal history can and was considered by the trial court in determining that a 22-year sentence was appropriate here, and we're not challenging whether that initial sentence was contrary to law. Then what happened, second, is that the trial court made a specific finding related because of Mr. Bryant's outburst, put that finding on the record and said, because of the outburst, I find that I no longer find that you're remorseful, and I'm adding 6 years to your sentence. As Justice Fisher pointed out in his concurrence in Jones, when a trial court does make a finding under 2911 or 12, that finding is subject or should be subject to appellate review in limited circumstances. Here, where what Mr. Bryant did is punishable without a doubt is contempt of court for his disruption. Nothing else he did provided further information or provided any relevant basis related to a sentencing factor for increasing a sentence by 6 years.
Counsel, did your client accept responsibility for the crime?
In a sense, yes, and I acknowledge his statement of remorse wasn't perfect in the sense that he didn't make reference to the victim, for example, but the trial court, in weighing that, didn't say, I find the most remorse possible. The trial court found some remorse. So
okay, so what exactly did he say for indicia of remorse?
Well, he acknowledged that he's made a lifetime of bad decisions, and
okay, that's bad decisions in the past. For this particular incident, crime.
There may not have been a statement directly related to this crime, but what he did acknowledge was in his life, and including this conviction, related to a lifetime of bad decisions and criminal convictions, and that he caused harm to his family, for example, and he said he can't continue to blame other people, and he has to be the one to make any change in the future.
All right, so you're saying that he accepted responsibility for his past actions.
Correct.
Okay, but not so much as to I'll accept responsibility, but only if I get a sentence I like.
No, that's not, the record doesn't show that. The trial court did find some remorse in Mr. Bryant's statements, and what happened after the sentencing announcement, the trial court may have believed that subjectively that this was an insincere statement of remorse made previously, but that reasoning by the trial, that was not a reasonable finding by the trial court, and the record just doesn't support it, where Mr. Bryant's post-sentencing statements didn't contradict those statements, where the trial court did credit him with some remorse.
Don't they do kind of contradict what he said, right? He says, I can't continue to blame others for my actions and my behavior. I have become jaded towards the legal system. Having this trial was honest and eye-opening for me. I have a newfound respect for the efforts of the attorneys, judges, jurors, and goal in giving an accused person an opportunity to have a case heard. That's all anyone can ask. I am thankful for the opportunity afforded by the court, by the day in court, and I respect the decision the juries have made. I alone have the power to end this cycle of incarceration. Now, and the judge presumably found at least that had some impact. He said that was, he found that there was remorse, and then your client turned around and said things that directly contradicted what he had just said.
Well, there are parts.
I mean, you have to admit that his behavior afterwards is directly contradictory to some of his statements.
It
I
was
have
contradicting.
respect for judges in the legal system.
It was contradictory to some of his statements, but those were not. But I'll concede that those were not statements of remorse. Those weren't saying I respect the judge, the jury, and the lawyer. I don't take those to mean those to be comments as sincere regret or sadness over what he did in this case. There were other pieces of that statement that more accurately meet that definition that I set forth at the beginning.
Well, whether you call it remorse or not, I mean, it is fair to say that his actions immediately after sentence were directly contradictory to what he just told the judge. True?
Yes, but the statements that were contradicted, we do not contend were related to remorse, because just as much as disrespect towards the trial court's not a sentencing factor, nor is showing respect or deference to a trial court at the same time.
Accepting responsibility, I think, certainly is part of remorse and how a judge is going to sentence someone.
Yeah, and he did accept some responsibility in his statement. It's just that the comments about the court and the legal process were unrelated to that. And I see I'm over my time. Unless this court has any other questions, I'll just ask again for this court to reverse and modify Mr. Bryant's sentence by vacating the 6-year increase. Thank you.
Thank you. Ms. McGee.
Thank you, Chief Justice O'Connor. May it please the court.
Ms. McGee, I want to ask you a question that I wasn't able to ask your colleague, and I think either one of you could answer it. But essentially, what the judge did was increase the sentence by 3 years to a maximum on each of the 2 counts that were being served consecutively. And
Correct.
wouldn't the statement that she made in doing that really have to go to supporting a maximum sentence under the statute? And is that how we should be looking at it? But she already made her reasons for consecutive. And so what she essentially did was said, I'm going from 8 to 11 years on the 2 counts that I've already given reasons for consecutive. And all she really needed to do was to give a basis for why it was the maximum now. I mean, and so wouldn't we be analyzing what she said in relation to maximum sentences?
On those 2 counts, Your Honor, I think that would be correct. But I would argue that the maximum sentence on those 2 counts was warranted. And it was not a maximum sentence versus the entire exposure. There was the 2 counts that were run concurrent time.
Right.
And I think,
Counselor, wait a minute. How can you say they're warranted when the court didn't give them at first and the state didn't ask for it?
well, ultimately, the determination of an appropriate sentence and the appropriate way to weigh the purposes and principles of sentencing comes down to the trial court. So yes, in this case, the state did ask for a minimum of 20 years. I don't think that's necessarily in contrast with the sentence that was imposed in this case. The state wasn't capping its recommendation at 20 years, and in asking for a minimum, I think that's in line with what the judge determined was an appropriate sentence in this case. It's not as if the state.
Well, then the judge gave 22.
Correct.
So then how is the additional 6 years? Where is that authorized? I mean, where does that come from?
Well, the 6 years is within the statutory range that's set forth regarding this.
But it's not what the judge gave. The judge gave 22. There was the outburst and the tirade and the allegations of racism, and then he gets 6 more years.
So I would respond to that in that the record sort of indicates that the judge intended on imposing that 28-year term in the first place, because he notes that he does find a certain amount of remorse and offers mitigation to the appellant because of that expression. So it isn't as if the 22-year sentence was the judge's initial sentence. It appears that the 28 sentence was what the judge initially intended to impose on these sentences, i.e. the max on those first 2 counts. However,
Counsel, let me ask you about that. So my review of the record, Mr. Bryant was 32 years old at the time of the sentencing, and the initial sentence, he found out he wouldn't be released from prison until he was 54. And then after the outburst, he found out he wouldn't be released till he would reach the age of 60. So, or after the sentence. I want to give you a hypothetical. Had the judge said, as a result of this outburst that you just displayed in my courtroom, I'm going to add 6 more years to your sentence, and that's all, would that be a lawful sentence?
The state would submit that would be a lawful sentence. It would make appellate review more
sorry.
challenging.
I'm sorry, did you say would or would not?
It would. It would be a proper action of the court to increase appellant's sentence without making that specific finding that it's related to his expression of remorse. However, it does help with appellate review that we know exactly what the judge was thinking in this case because he enumerated that finding on the record.
Well, where in the statute does it say the judge can consider courtroom behavior at sentencing to impose additional terms related to what the legislature says can be punish the crimes of robbery and burglary? Where is that? Can you point to a statute where that a judge can consider that?
Well, the judge is required to consider the statements that are made on the record at the sentencing hearing. And I would argue that the judge's determination that the courtroom conduct indicated a lack of remorse, not that that was what the judge was considering as far as a sentencing factor. He directly related the conduct to a specific finding enumerated in the statute.
But the original 22-year sentence, the judge said he considered his genuine, what he perceived as genuine remorse as mitigating. And that's what led from the 2 robbery and burglaries going from 11 to 8. And so he said that the outburst betrayed that he wasn't sincere. Can you explain how does an outburst in anger at the reaction of the severity of a sentence betray that he wasn't remorseful 10 minutes earlier in his allocution? Even the Court of Appeals had a problem with that logic.
I would take issue with that necessarily, but as Justice DeWine stated earlier, the statements that the defendant made after receiving his sentence were in direct contrast to the statements he made prior when he was expressing remorse. Secondly, to your point regarding the reaction to the severity of the sentence, the state would submit that that does demonstrate a lack of remorse. It shows a cynical and remorseless contempt for the law. It fails to recognize the severity of the appellant's conduct in this case. It also shows an inability for him to control himself in free society. All of those factors directly relate to a defendant's likelihood to recidivate once he's released.
Ms. McGee, I need an answer to the question. Did the judge put enough on the record in giving reasons for the sentence, regardless of at which phase it was, to support consecutive sentencing or to support the maximum sentence on the 2 counts when the judge increased it from 8 to 11 years on each count?
Certainly, I would argue that under the statutory findings, the sentence in this case was warranted based on the offenses that were committed as well as the offender who committed them. And the judge enumerated those findings specifically on the record.
Counsel, let me ask this question then. Based on what you're saying, how can a reviewing court, looking at the exact words of the disrespectful outburst, related to the shock or surprise about the severity of the sentence, and your argument here that it showed his lack of remorse, or the trial court saying it shows lack of remorse, it's no more connected. If we find that his outburst is no more connected to a showing or lack thereof of remorse as it is to whether he likes pizza, how can a reviewing court ever determine whether a sentence is being imposed based on improper or inappropriate factors? What does the reviewing court weigh, particularly if the trial court statement, I find that you obviously don't have any remorse, doesn't have any relationship to the comments? Are we to allow the discretion of trial court judges to just be unabated? How do we review that? Or the appellate courts, Supreme Court, how do we review whether it's inappropriate, whether there's inappropriate factors or just simply human nature of being personally offended that come into play when the statutes don't allow that?
The state would submit that the appellate courts review those to make sure that the record is not clearly and convincingly, or the finding is not clearly and convincingly unsupported by the record, which is exactly what the 11th district did here. They looked at the trial court's finding and the fact that the trial court determined that the outburst was directly related to the appellant's lack of remorse. They found that given the circumstances of this case, this specific case, that finding was reasonable by the trial court. The court could infer that that outburst was a sign that the previous expression of remorse was in fact insincere. So it's not unfettered discretion to the trial judge, but in a case like this, where obviously there is a difference in opinion as to what appellant's outburst was and was not, because defendant himself states that it wasn't a showing of remorse, and the trial judge determined that it was. So when we have two conflicting opinions, both of which are sound, I would argue that the judge's determination is much more reasonable in this case. Who do we defer to? And the state submits that we defer to the trial judge, who is in the best position to make these types of determinations.
So let's assume hypothetically the trial court increased his sentence by 6 years simply because the trial court judge was angry and offended. Would the 6 years be appropriate?
No, Your Honor. I would argue that it's not appropriate to increase an appellate sentence based on the fact that your feelings got hurt. But I would also submit that there's nothing in the record to show.
Well, then, but how can we review that?
Well, I mean, you're stuck with the record that's sent to you, and the judge on the record made relation to his finding. He didn't come out and say, "Oh, you're disrespecting me 6 more years." He specifically said, "I thought you were showing some sort of remorse. You clearly were not, and I'm increasing your sentence based on a finding that there is no remorse." And in this case, that was the only mitigating factor in appellant's sentence. There was nothing else that would have mitigated his sentence.
But counsel, earlier you told me that in my hypothetical, if he would have said, as a result of what you just did, I'm adding 6 more years to your sentence, you told me that would be a lawful sentence. That would not be contrary to law.
Yes, the state's position is that would not be contrary to law. It would make appellate review more challenging. And hypothetically, a court could say, we don't know why the judge did this, and we're not sure if this was proper. And so in that case, maybe it would warrant remand, despite the fact that the sentence is not necessarily contrary to law. In that case, the appellate court may not be clearly and convincingly sure that the finding was supported by the record because they're not exactly sure. But that is not what happened in this case. The judge specifically enumerated that finding and the revision to his finding then on the record when he increased the sentence. So we know why the judge did what he did here.
Counsel, in the exchange, Mr. Bryant's outburst, he accuses the judge, he says she never gave him probation or any, something to the effect, let me pull it up, about, was his expectation was he was going to get probation.
Correct.
That's the only way I can read that.
Yes, and the state submits that that is not a reasonable expectation. There was a presumption for prison in these cases or these offenses. There was mandatory gun specifications in these cases. Prior to trial, the state's plea offer contained prison time. The defendant knew from the state sentencing memorandum that the state was asking for consecutive sentencing. There was actually even a merger issue that was still pending prior to sentencing, where the defendant in this case could have received an additional 14 years had the trial court not merged the kidnapping with the robbery.
And I
So-
understand that counsel, I understand your point that she gave him as much consideration in the first iteration of the sentence as she thought appropriate, given the circumstances, his statements, etc. But his unrealistic expectation of probation and saying that she never gave him a chance, which is a direct quote, indicates to me that his remorse was he didn't understand, I think, what the whole situation was, and what he voiced it at showing remorse was his attempt at justifying probation.
I think I would disagree with that position, Your Honor, because when the defendant makes his initial allocution, he sort of recognizes that he is going to prison. He says that to the judge, and he asks that he says he doesn't want to die in prison. So the state would submit that the defendant was well aware that he was going to be sentenced to prison prior to receiving that sentence.
Probation wasn't even on the table. Isn't that correct? It had to be a mandatory sentence because of the gun specification. So he had no expectation of probation. He was just looking for something proportional to what the co-defendant received.
Yes, Your Honor, and I would like to briefly address that statement where you were discussing the culpability of Bynes. The state's position is that Mr. Bryant and Mr. Bynes were equally culpable in the robbery and the burglary of Mr. Gonzalez. Yes, the evidence did show that Mr. Bynes was the individual who physically possessed the gun during the robbery. But if we believe that information, the testimony at trial was that Bryant was the first individual to enter the room, because the victim testified that the second person who came in his room was the one who was carrying the gun.
Well, but Counselor, isn't it Mr. Bynes who cased the place? The two co-defendants cased the place. I mean, everyone's culpable, obviously.
Yes, and I disagree with opposing counsel's classification, characterization that they cased the place. The evidence showed that Ms. Medina was well aware of how to enter that trailer prior to the evening of them going there. She was friends with the victim.
Ms. Medina and Mr. Bynes went first. There was no evidence that Mr. Bryant was involved in hatching the plan or scheme to commit the crime. Is that
That's not correct. The two co-defendants, they went to the victim's trailer to get money so that they could go buy drugs. They were not there to case the trailer. I understand why opposing counsel characterized it that way, but that's not necessarily the state's position on what the evidence showed. And I would also briefly like to point out, because I recognize my time is over, just to address an issue earlier, the record does reflect that both Mr. Bynes and Mr. Bryant are African Americans. The victim testified that two quote unquote black men robbed him, and that came out during testimony at trial that both Mr. Bryant and Mr. Bynes are African American.
okay?
One more question, if I could. Did the
Sure.
state advocate for consecutive sentence on the co-defendant that fled in this case?
I can't speak to that directly, Your Honor. I'm not sure if we advocated for consecutive sentencing. I know that the co-defendant was given the benefit of his plea agreement and did plead to lesser offenses than the defendant in this case was facing. I can't speak specifically as to what our sentencing recommendation was in that case.
All right, thank you.
Thank you.
Just a follow-up.
Go ahead.
When he said you never gave me probation, is it possible that he'd been before this judge before because of all of his repeat offenses?
Yes, Your Honor. The record indicates that this is the fifth case that this appellant had before the judge. And the state would submit that that is why the judge was in the best position here to make the determinations that he did regarding the appropriate sentence for the appellant in this case. So yes, the judge is very familiar with this appellant. He has sent him to prison prior.
Because I saw you never gave me a chance after you never gave me probation. Thank you.
Thank you.
Thank you.
Mr. Hirsch. You've used your time. You may take a minute.
Thank you. There's one point I want to zero in on rebuttal here, and it's the trial court's failure to make a reasoned decision in light of the circumstances of this case. Mr. Bryant's outburst came immediately after the trial court announced that the aggregate sentence would be 22 years long. His comments were directed at the trial court and related to his sentence. He disrupted the proceedings, and it's undisputed that this constituted contempt. But to modify Mr. Bryant's sentence based on in-court behavior, it has to be related to a sentencing factor. And the trial court mistook this disrespect, this disruption as being related to remorse here. And the trial court failed to do what this court cautioned the trial courts ought to do in Bachman when considering disruptive courthouse behavior. And it's not to suggest that the trial court here did something sanctionable or is egregious, but the principle stands that the trial court could have taken a pause, could have had Mr. Bryant escorted out of the courtroom and then resumed proceedings. But instead, the trial court had an immediate reaction to behavior which amounted to nothing more than contempt of court. And just because the trial court cabineted it in the language of a sentencing factor doesn't make it so, when the only interpretation of the evidence supported by clear and convincing evidence on this record is that Mr. Bryant's reaction was purely a reaction to a sentence that he was not expecting, whether that's the 10 years as counsel suggested, whether that's probation, even irrespective of whether that was a reasonable expectation. That's what he was reacting to.
Thank you.
So, thank you.
Thank you, counsel. We will take the matter under advisement and be notified of our decision. Our last case this morning is 2020-643, Rancho Cincinnati Rivers LLC versus Warren County Board of Revision et al. For the appellant, Mr. Byrne.
Good morning, Your Honors. Chief Justice, and may it please the court. My name is Jeff Byrne, and I represent Rancho Cincinnati Rivers LLC. I'd like to reserve 3 minutes for rebuttal. Your Honors, this case can be resolved with a simple and plain interpretation of well-established Ohio assessment law. Ohio is a market value state for tax assessment purposes, meaning that property should be valued based on what it would sell for on the open market as of the assessment date at issue. This is what we can refer to as a hypothetical sale. The next question becomes, what legal interest must be presumed to have transferred in that hypothetical sale? The 129th General Assembly in 2012 stated that property must be valued in the fee simple estate as if unencumbered. This court, in the case often referred to as Lowe's 2, stated that it is plain that a lease is an encumbrance, and revised code 5713.03's directive to value the realty as if unencumbered means that property should be valued as if it were free of lease encumbrances. It should simply follow that property tax assessments in Ohio must reflect what a property would sell for in a hypothetical sale when the property is unencumbered by a lease. Free of lease encumbrances, that means no lease in place. This simple directive of 5713.03 has not been so plain to tax authorities opposing taxpayers in assessment appeals, as well as the Board of Tax Appeals and courts some courts throughout the state, which we're dealing with the Warren County Court of Common Pleas and 12th District Court of Appeals. Rancho is asking this court that a property that is leased at the time of transfer is not free of lease encumbrances. This court has not made the leap, the logical leap from property must be valued as if free of lease encumbrances to that a property that is leased at the time of sale is not unencumbered. This should seem obvious, but this is the issue that keeps coming up in these assessment appeals that Rancho is asking this court to resolve. A property that is leased at the time of sale has the presence of the incumbent of an encumbrance, whether or not that encumbrance is at market. The presence of an encumbrance affects property rights, something that is often referred to as the bundle of rights. A lease encumbers a property by preventing the purchaser from occupying the property themselves or leasing it to another. These are two of the what we call sticks in the bundle of rights. A lease that is not at market, a lease that is at market, both of those encumber the property, both of those affect the bundle of rights. The only way a property can transfer unencumbered is if the property transfers without a lease. There's no evidence that the General Assembly meant anything other than unencumbered when they wrote the words as if unencumbered in the statute. The 12th district, which is on appeal in this case, the 10th district in the Lowe's versus Cuyahoga County Board of Education case involving the Brooklyn City Schools, which was heavily cited by the 12th district, and the Court of Common Pleas have invented these standards for interpretation of Revised Code 5713.03 that have no basis in the plain words of the statute that say as if unencumbered. Paragraph 29 of the 12th district decision states that property is to be valued in its current use as a functioning occupied store. They go on to say Rancho and its appraiser would value an occupied property like the property in this case as if it were vacant on the tax lien date rather than occupied and rented at market rent. The Court of Common Pleas in this case stated RASIC valued the property as if the first occupant of the structure had left and the property was sitting for sale vacant. This hypothetical property is not the property we have at issue in this case. There is no exception to the as if unencumbered language of 5713.03 when the property in question is actually leased on the assessment date or actually occupied by a retailer, whether or not that's its original tenant, original occupant. The words as if create a hypothetical. So whether the property is owner occupied, whether it is totally vacant, or whether it is currently occupied, the property is to be valued as if unencumbered. There's simply no support for the courts to carve out an exception to this plain language when the property in question is actually leased or actually occupied. I think this court should contrast these invented standards by the Court of Common Pleas in the 12th district with the application of the law by Magistrate Hasselbeck in this case, who heard the appraisers, heard the initial arguments in this case. He stated the property which is subject of this appeal is encumbered by a lease. A plain reading of Revised Code 5713.03 suggested it must be appraised as if unencumbered. It would follow that any comparable sales of encumbered properties must be adjusted to reflect the absence of a lease. It does not follow in the magistrate's view that encumbered comparable properties may be used in a comparable sales approach unadjusted merely because the rent for such properties is at market rate. Rancho asked that this court apply this plain reading of the law in this case and hold that a lease at market rent is not an unencumbered property. I want to also address the 10th district decision, which was cited by the 12th district in this case. It seems the 10th district and some of the other decisions citing it underpinning these decisions is the feeling that the revisions to 5713.03 and the words as if unencumbered simply change nothing when it comes to Ohio assessment law. The 10th district wrote in paragraph 28 of that decision, the unencumbered language added to the Ohio Revised Code in 2012 implied some changes to the precedent previously set by case law, but not to such principle. There's simply no support for the notion that the words as if unencumbered meant nothing and were meant to change nothing. In fact, this court in 2009 in the Meyer decision, footnote 4 of that decision, held that the terms lease fee and fee simple were distinctions made by appraisal law and not by the assessment law of the state of Ohio. The words "as if unencumbered" added in 2012 can be seen as a direct rebuke of that holding. The General Assembly in 2012 said, with the words "as if unencumbered," have now stated that Ohio's law mirrors appraisal theory that a lease is an encumbrance and property is to be valued as if unencumbered.
But Mr. Byrne, this was a case before the Board of Tax Appeals in the Brooklyn school case. And I feel like you're kind of mixing apples and oranges here, because I'm not even sure why you didn't go to the Board of Tax Appeals and why you went this route. But we were talking about the special purpose doctrine. I mean, the court was talking about the special purpose doctrine in that case.
I referenced the Brooklyn Lowe's decision, which emanated from the Board of Tax Appeals, because it was cited by the 12th district in this case. And I think it's important to note, and the quote that I just read from the 10th district was cited by the 12th district in this case. It's important, while the 10th district decision did invoke the special purpose doctrine, it also made a holding regarding the interpretation of revised code 5713.03 that had nothing to do with the special purpose doctrine. The 10th district seems
what the decision says in paragraph 28 is that the unencumbered language that was added to the statute implied some changes to the precedent that was previously set by case law, but not to the principle. It didn't wipe out the special purpose doctrine.
I believe that statement was relating to all assessments in general. The notion, if this court were to hold that the special purpose doctrine remains, of course, yes, the special purpose doctrine does remain and can remain an exception to 5713.03, but there was no special purpose doctrine invoked by the 12th district in this case. The 12th district held that this property can be valued as if it were encumbered by a lease on the assessment date. And that is a plain error of law under revised code 5713.03 that states the property must be valued as if unencumbered. And with that, I'd like to reserve the rest of my time for rebuttal.
Thank you. Thank you. We have two appellees. I believe that our first is Mr. DiMuzio.
Oh, yes, Your Honor. My name is Dave DiMuzio. I'm the attorney for King School District. I'll be speaking for about 12 minutes, and I'd like to reserve 3 minutes for Mr. Watkins, who's the attorney for the county. As I sat listening this morning to Mr. Byrne, I thought I was listening to the oral argument for the Lowe's 2 case. These are the same exact arguments that we heard and the court rejected several years ago. I just wanted to quote, because it's so important, the main holding of the Lowe's 2 court, where they talk about the specific language, and they say that the language of RC 5713.03 applies to the valuation of the property itself. It does not prescribe any standards to be applied in a comparable sale analysis. Lowe's statutory argument, in effect, would have us insert words the General Assembly did not use. We declined to do so. They're again asking this court to apply new standards to comparable sale analysis. And as far as we're concerned, Lowe's 2, handles all of the issues that we have here today. And if that wasn't enough, if the court were to look at the reply brief that Mr. Byrne filed, at the bottom of page 15 of the reply brief, they clearly show that they're still consumed by Lowe's 2, and Lowe's 2 is the real issue. They begin the last paragraph by accusing me of misrepresenting the facts when I said appellees are not arguing the property should be valued as if already leased in italics. He then cites to page 55 of Mr. Burt's testimony. You'd think when you went there, there'd be some support for this allegation that I misrepresented it. You'd think there'd be something on page 55 in which Mr. Burt admits that he looks at this as if it was already leased. Nothing like that is on page 55. When you go there, it is simply Mr. Burt talking about his comparable sale analysis, talking about how he looks at leases to see if they're at market to determine whether or not they're representative of fee simple. So what does this mean if we're assuming that they're acting in good faith when they make this assertion? What they're really saying is if an appraiser applies the principles of Lowe's 2, they violate the statute. So when they attack Mr. Burt, they're really attacking this court's holding in Lowe's 2. There's a distinction between how you value the actual property itself on the day of valuation and what methodology you use and what comparable sales you look in order to find out whether or not that's accurate. Mr. Burt did not assume a lease was already in place. How do we know that? It's in his report. On page 10 of his report, he actually says he defines fee simple as absolute ownership unencumbered by any other interest. Judge Peeler, in his opinion on page 12, quotes Mr. Burt, in which he says, Burt assumes the property was, quote, owned in fee simple and transferred in fee simple. So please understand that. As far as we're concerned, that takes care of about 90% of Mr. Burns' argument. It's based on this false premise that Mr. Burt knowingly and fully and completely tried to appraise the subject property as if it were already leased, and he's not done that. When somebody acquires fee simple, they acquire the whole bundle of rights, including the right to earn income through leases. And what Mr. Byrne is really focusing on is what I call a nanosecond. He's saying, well, yeah, you can look at leases, but the truth is on January 1 at midnight, when you do the valuation, you have to assume there's no lease, which is true. And we should make a large adjustment. He has no market basis for this, no study. But if it takes a nanosecond or 5 minutes or 10 minutes to actually enter into a lease that generates income, we must make this huge adjustment. And of course, that's not realistic. That's not how properties buy and sell. People don't buy it to own it for a nanosecond. They buy it to own it long term. It's a highly hyper-technical kind of argument. If you read appellant's brief, you'd think this entire case resolves around this statutory issue. But if you look at it from 30,000 feet, what's really going on is, and if you read Judge Peeler's opinion, he meticulously goes through all the evidence from both appraisers, talks about the pros and cons, talks about what kind of leases. And what he concludes, if you read it, is he really, really doesn't like Mr. Rasick's analysis above and beyond this issue of fee simple. He talks about the inferior sorts of comparables he uses. He uses many comparables that didn't even sell. They've been on the market for years and years. They're clearly failed properties that can't attract interest. The subject property is a highly successful retail location with other retail locations that are highly successful right next door. So this concept that somehow we should be focused just on this hyper-technical issue, we think is, mostly irrelevant, because even if you found some merit in what they're arguing, it's not really what the case was decided on. There's umpteen other reasons why Judge Peeler decided the way that he decided. He correctly cites Lowe's 2. Lowe's 2 came out right before we had to start briefing to the magistrate. And again, we thought it resolved all the issues. So frankly, we're surprised we're still here, but we think the court clearly understood that in order to figure out what income potential in this bundle of rights a potential owner has, you simply have to look at leases in the marketplace. And if they're not at market, then you go ahead and make your adjustments. Mr. Burt did make his adjustments. He calls them locational. In Lowe's 2, Mr. Sprout, who this court upheld, the appraiser there, he also made adjustments. He called them property rights, but they were the same sorts of economic adjustments. The majority of the comps in Mr. Sprout's analysis also were at market. And so the adjustments he made reflected the fact that the rents in the comps were higher for the most part than the rents in the subject, and therefore he had to make downward adjustments. Mr. Burt did much the same thing in his analysis. The appellants mischaracterize what Judge Peeler did. They make a statement on page 4 of their merit brief, in which they say, quote, Judge Peeler held that accepting Rancho's argument that its property should be valued as free of legal encumbrances would be legal error. That is not what Judge Peeler said. What he actually said was this: to interpret the law as requested by Rancho to eliminate leases entirely from any property valuation would be legal error. All roads lead to Rome. All roads lead back to Lowe's 2. What they're really saying, if they're acting in good faith here, is what they're really saying is this court made a mistake in Lowe's 2. This court should not have ruled that it's okay to use lease fee comparables when you're doing an analysis of fee simple property. They also mischaracterized the 12th district holding. Let me quote from their brief, page 5, quote, the 12th district rejected Rancho's argument that the subject property should be valued as if unencumbered. Not only is that not what the 12th district said, they said just the opposite. Let me quote page 7 of the 12th district's opinion, quote, for real property tax purposes, the fee simple estate is to be valued as if it were unencumbered. How could it be any more, opposite than what they allege? And they cite to the Alliance Towers case. I also wanted the court to understand that Mr. Rasick, the appraiser for the appellant, failed to abide by the dictates of Lowe's 2 in his treatment of many of his leased fee comparables. I cite the court to page 39 of his report, supplement 48, where he talks about comp number 6. It has a lease on it. Guess what? He makes no adjustment for that lease. He doesn't talk in there about whether the lease is above or below market. He violates Lowe's 2. Page 41, he talks about a Burlington Northern comp. No analysis of whether or not the lease is above or below market. Finally, on page 45, he looks at a Lowe's, which is what the subject property is. He looks at a Lowe's comparable. He makes no mention of whether the lease on that Lowe's is above or below market. Mr. Byrd, of course, does do that in-depth analysis. He does look at it, and he makes the appropriate adjustments, whereas Mr. Rasick didn't. I don't know if the court has any more questions, but I've really gotten through what I wanted to talk about, and I'll be happy to defer to Mr. Watkins if there's no other questions.
Thank you. Mr. Watkins.
Thank you, Your Honor. May it please the court. Mr. DiMuzio covered a great portion of what I was going to argue also. Specifically, the Lowe's 2 case, we believe, is the controlling case for this court to consider. The language that Mr. DiMuzio quoted that in Lowe's 2 that says that the language of RC 571303 applies to the valuation of the property itself, does not prescribe any standards to be applied in a comparable sales analysis. Your Honor, Mr. Burt did indeed value the property fee simple as if unencumbered according to what the statute requires. When a property is valued fee simple unencumbered that does have an existing lease on it, the job of the appraiser is to take the effect of the lease out of the equation. And then you look at the bundle of rights that the owner of the property would have as if they were going to lease the property. And certainly if one of the bundle of rights of a fee simple interest is the right to lease it at economic terms. Mr. Burt in his appraisal looked at that. He looked at the market. One thing I did want to point out about Mr. Burt's appraisal report is he did verify all of the sale data and lease data with independent brokers and the buyers and sellers, and it is indicated in his report. Mr. Rasick, it does not appear in his report that he actually did verify the data. And Mr. Burt did look at the market to see if it were at market, and then also did make adjustments based on the fact that certain conditions would favor, at a certain time in the lease, would favor the current valuation versus not using or making a downward adjustment if it was not the same economic period. And also, as far as the location of the property, a property in a certain market may be there may be the same market condition, the same property rights, but it may be a different market, so you have to adjust for the location. And that is what Mr. Burt did in his report. He did reflect the market conditions and location and made adjustments for those. So he did, in fact, look at the market and evaluated as such. I believe if you look at the comparables that Mr. Rasek used, he used a lot of what we call second generation properties that are vacant and have had a long-standing vacancy and have not been leased for a considerable amount of time. In fact, in his lease, his income analysis, a lot of the leases that he used were for older properties, and also I think the last 7 or 8 of his leases that he now analyzed in the income approach really did not have any data as far as actual lease rates. I think they were just available to be leased rather than actual leased. So if you look at the actual data and complying with the court's requirements, I believe Mr. Burt did a much better job. And the trier of fact, Judge Peeler, did weigh both appraisals and determined that Mr. Burt's appraisal was more probative and competent evidence. So I would ask the court to affirm the decision.
Thank you. Mr. Byrne, you have a little over 4 minutes left.
I'm sorry, Your Honor. I did try to raise my hand for a second. Is it too late?
Yes, yes, sir.
I'm sorry.
Mr. Byrne.
Thank you, Your Honor. First, I'd like to address the implication by counsel for the Board of Education that Lowe's 2 controls that Rancho was somehow fighting the Lowe's 2 decision. The holding of Lowe's 2 is what I said in my initial argument and was cited in the brief many times and was ignored essentially by the Board of Education in the county, that a lease is an encumbrance and that 5713.03's directive is to value the property as if it were free of lease encumbrances. Counsel for the Board of Education in the county keep saying that the way to adjust for property rights under Ohio law is to determine whether the leases in place are at market. Rancho asks, where does this emanate from? This standard clearly conflicts with the plain language of 5713.03, and the standard doesn't appear in any decision by this court. I'd also like to address the other portion of Lowe's 2 that was cited by Appleese, that 5713.03 does not prescribe standards under the comparable sales approach. What that quote cited by Appleese clearly says that 5713.03 controls the valuation of property. And so an appraiser can use any comparable sales that he or she would like to use in a comparable sales analysis. But if a finder of fact determines that a property can be valued as if it were encumbered on the assessment date, that it can be valued as if it transfers in this hypothetical sale encumbered by a lease, then that is clear legal error. And that's exactly what the Court of Common Pleas did in this case, and that's exactly what was affirmed by the 12th District. And so Rancho is asking that this court apply the statement it made in paragraph 19 of the Lowe's 2 decision, because that standard has not been applied by the Court of Common Pleas or the 12th District. I'd also like to address counsel for the Board of Education's characterization of the real estate market and talking about this nanosecond theory when it comes to when a property transfers. The Board of Education is right in a sense that property must be valued based on what it would sell for if it is unencumbered on the assessment date. And there's market data in Basics report and even here and there in Burt's report that shows a difference between the value of properties that sell unencumbered and the value of properties that sell encumbered. It doesn't matter whether the buyer of the property takes owner occupancy, tries to lease the property. What must be judged is the property rights that transfer at the time of sale. Finally, I would like to address the notion that Mr. Burt, the Board of Education appraiser, did adjust for property rights. That's simply not true. In page 158 of the supplement, when talking about property rights, Mr. Burt states that the rent and lease terms were in line with the market and no adjustments were made to the sale price for above or below lease rate terms. In the previous Rite Aid decision that occurred before the revisions to 5713.03, the appraiser in that case did the exact same thing. The court called it illogical on its face. And with that, unless there are any questions, we respectfully request that the court find that the property must be valued as if unencumbered.
Thank you, gentlemen. We'll take the matter under advisement and you'll be notified of our decision. Marshall, will you please adjourn court?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.